Former Secretary of State Hillary Clinton spoke about voting rights today at the American Bar Association's annual meeting. She talked about the U.S. Supreme Court's decision to strike down part of the Voting Rights Act and recent laws passed around the country impacting people's ability to vote. The former Secretary of State also received the ABA Medal. That's the highest honor the organization gives for service in the cause of American justice. From San Francisco, this is 35 Minutes.
Thank you very much. Thank you all very, very much. Thank you. Thank you very much, President Bellows. Thank you, Mr. Chairman, members of the House of Delegates, incoming President Jim Silkenat, friends and colleagues, longtime members of the ABA. I am so deeply grateful to you for this award, and I am humbled by those who have received it in the past to join their company in some small measure to continue the work that the ABA has championed. I know that earlier you heard from Attorney General Holder about important issues in our criminal justice system. And this afternoon I want to raise another such issue, voting rights. Another area where the ABA has been particularly active all of my professional life, and to share some perspectives from 4 decades as a lawyer, a legislator, a diplomat, about why voting rights are so foundational to our democracy and our future. But first, I want to underscore that this honor from the American Bar Association means so much to me because I know the work that the ABA does. It is hard to believe it's been 25 years since then ABA President Robert McCrate called me in my law office in Little Rock and suggested that I chair the first commission on women in the profession. He was very persuasive. And we held hearing after hearing, recording the experiences of women lawyers, judges, and professors. In fact, a number of my colleagues from that first commission are here with us this afternoon. No one at the ABA ever suggested that we hold back, go slow, avoid the hard truths. And I'm proud that the ABA helped start the movement for gender equality in the legal profession, and that it continues to be at the forefront today with initiatives to ensure that equal work really does mean equal pay. I want to applaud President Bellows' leadership in combating human trafficking at home and abroad, and so many other issues where America's lawyers can and should lead the way. I'm well aware, as you are, that some people, hard to believe, see lawyers as part of the problem in our society. But I learned very early on that lawyers are often essential to the solution to any problem we face. As Secretary of State, I saw the contributions that the ABA makes around the world. Your Rule of Law initiative is helping to improve governance, deliver justice, and promote human rights in more than 60 countries. A few years ago, I had the chance to visit members of the Azerbaijan Women's Bar Association, who were fighting domestic violence, child marriage, and other abuses in a country without a strong tradition of the rule of law or a vibrant civil society. The ABA's support made an enormous difference to these women. The World Justice Project, launched by former ABA President Bill Newcomb, has developed a rule of law index, which I found very helpful. It measures governance around the world based on 4 universal principles. First, that governments, people, and corporations should all be accountable under the law. Second, that laws must be clear, publicized, stable, and just. Third, that laws are enacted and enforced fairly and efficiently. And fourth, diverse, competent, and independent lawyers and judges deliver justice under the law. Now, these are essential concepts for any healthy democracy, including our own. And although we use the term rule of law, it's not only about how law governs society, but also how law serves society. I mean this in at least two ways. First, that law can be an instrument for improving people's lives in addition to adjudicating their disputes and shaping their government. And second, that the law belongs to the people, that its power flows from their consent and participation. This is about making the law real and vibrant as opposed to arid and abstract. It is also about ensuring that while the law should never privilege the rights of some citizens over those of others, we should not be afraid to privilege justice over injustice. As I witnessed as Secretary of State over 4 tumultuous years, the search for justice drives people to stand up against dictatorship, corruption, and oppression. And rule of law is the most powerful tool in human history to deliver this justice. As a young law student, I volunteered at the New Haven Legal Assistance Association. Although the work I did there sometimes felt a million miles away from the classrooms where we debated precedents and procedures, it helped me see lawyers giving life to the concepts in my textbooks, using them to solve real problems facing people every day, and it inspired me to later take a job as the first director of the University of Arkansas School of Law's legal clinic in Fayetteville, Arkansas. While there, I supervised students providing assistance to poor families and prison inmates. Now, not everyone at that time thought this was an appropriate use of the law. I remember there was one judge in particular, and maybe some of the Arkansas members might remember or even have appeared before him, Judge Butt, who insisted that my students qualify their indigent clients under a 19th century statute that permitted free legal assistance only when a person's assets were worth no more than $10 and the clothes on his or her back. Now, I told the judge that was an impossible standard for anyone to meet who owned an old car or even a television or anything else worth more than $10. But he held firm. So I went to the Arkansas Bar Association and argued that the law should be changed. How could we deny legal assistance when it could help save hungry children from poverty or protect battered women from abuse or stop unscrupulous bosses from exploiting their workers? Judge Butt made his case too, and the State Bar Association's executive committee listened to our arguments and then endorsed repealing the statute. Later, President Carter appointed me to the Legal Services Corporation, one of the great honors of my life. Now, once again, there were skeptics. We had to convince Congress that using the law to help poor families was a just and necessary cause, but it was worth it. We tripled our funding. We were able to pay thousands of lawyers to work on behalf of more than 1 million poor clients. We helped families avoid evictions, fight discrimination, receive their earned federal benefits. Often in those days, and many times since, I thought of something that Eleanor Roosevelt said about human rights. She reminded us that they begin in small places close to home, in neighborhoods, schools, factories, and farms, and there is no better tool to expand and enforce human rights than the law. We can and should use it to help more people in more places live up to their God-given potential. Because the law, after all, belongs to the people, not the other way around. It is no accident that the first words of our Constitution are, "We the people." Now, our nation was founded on the idea that power derives from public consent, not divine right or force of arms or discriminatory dictate. As Justice Sandra Day O'Connor put it, what was revolutionary when it was written and what continues to inspire the world today is that the Constitution put governance into the hands of the people. This is the basis for America's social compact. And while we may and certainly will debate amongst ourselves about the role and size of government, Americans of every party and stripe cherish government of the people, by the people, and for the people. Yet you know better than most that's easy to say. But here's where it gets trickier. If people are truly to own the law under which they live, they must have the access and information to understand those laws, to participate and have confidence in their government, and benefit from its policies. Despite our founding principles and the many ways our Constitution has protected individual liberties, we do, let's admit it, have a long history of shutting people out. African Americans, women, gays and lesbians, people with disabilities. And throughout our history, we have found too many ways to divide and exclude people from their ownership of the law and protection under the law. One of the first jobs I had after law school was with the Children's Defense Fund. Another pioneering lawyer, Marian Wright Edelman, wanted to find out why school enrollment figures were so much lower than the census of school-age children would have suggested. So as part of a nationwide survey, I went door to door in New Bedford, Massachusetts, asking whether the family had any children not in school. We discovered children staying home to care for younger siblings while parents worked, or even dropping out to work themselves in order to support their families. But we mostly found kids with disabilities who were not attending school. We found blind and deaf children, children in wheelchairs, children with developmental disabilities, children whose families couldn't afford the treatment they needed. I remember meeting a girl in a wheelchair on the small back porch of her house where we sat and talked under a grape arbor. She so wanted to go to school, but like many, she was excluded because at that time the public schools couldn't or wouldn't accommodate children like her. So along with many partners across our country, we collected the data and we brought it to Washington, and Congress eventually enacted legislation declaring that every child in our country is entitled to an education, including those with disabilities. The struggle to bring people inside, to give them real ownership of the law, is as old as our republic. This summer, we are marking the 50th anniversary of Dr. King's March on Washington and the 165th anniversary of the Seneca Falls Convention, signposts on our long march to a more perfect union and occasions to celebrate the progress we've made. But this is also a time to refocus on the remaining challenges. Confidence in most of our important institutions has fallen to historic lows, even as our need for solid footing in a rapidly changing world has never been greater. Skepticism of authority has been part of our national character since the Pilgrims, and complaining about government is a treasured American pastime. But it is troubling that many Americans continue to lose faith and trust in the press, in banks, in sports heroes, in the clergy, and just about every institution. According to data from Pew, majorities across all partisan and demographic groups express little or no trust in Washington. Stop and think about that for a minute. Because one of the observations that I've made traveling the world over on behalf of our country is how rare trust is. Yet trust is the thread that weaves together the social fabric that enables democracy to exist. When citizens are alienated from their government, democracy suffers. And around the world in recent years, we have seen what can happen when trust unravels and societies pull apart. In the Middle East, of course, but we've also seen growing middle classes in places like Brazil, Turkey, India, China demand more accountability and transparency from their governments. Now, America is the strongest and oldest democracy, and we remain a beacon of liberty and opportunity, and nothing made me prouder than representing our values these last 4 years. Yet many Americans are asking, how do we ensure that the law continues to serve and belong to the people in a time when ideology and gridlock have paralyzed our politics, when the advance of technology and the dangers of terrorism have complicated efforts to balance our desire for liberty with our need for security, when old demons of discrimination have taken on insidious new forms? These are all challenges, not just to our society, not just to our government, but to our legal system. They are strains on our social compact, but I am convinced that they are tests we can meet. Over the coming months, I will deliver a series of speeches focused on questions like these. Today, the assault on voting rights, which threatens to block millions of Americans from fully participating in our democracy and further eroding public trust. Next month, at the National Constitution Center in Philadelphia, I will talk about the balance and transparency necessary in our national security policies as we move beyond a decade of wars to face new threats. And later in the fall, I'll address the implications of these issues for America's global leadership and our moral standing around the world. So let me turn to the right to vote, because choosing our leaders is among the most direct and tangible ways in which citizens exercise their ownership over the law, and it is at the heart of America's democratic experiment. I know this is an issue more often addressed by secretaries of state in places like Florida or Ohio and elsewhere, but as Secretary of State for our nation, I saw firsthand that how we protect our freedoms here at home gives us the standing and experience necessary to defend human rights, democracy, and freedom abroad. I spent a lot of time over the past 4 years in countries that are trying to learn how to make democracy work. They need models to learn from, and I was proud that they most often looked to the United States. In Burma, for example, I talked for hours with generals who had taken off their uniforms and were trying to learn how to become legislators, and with dissidents like Aung San Suu Kyi, who were attempting to move from protest to politics. One Burmese leader of the parliament said to me, "We have been studying America and trying to understand how to run a parliament." I asked if they'd had seminars or workshops. "No," he said, "we've been watching The West Wing." You never know. And I saw time and time again people who were literally risking their lives for the right to vote. I'm sure you remember the famous ink-stained fingers in Iraq and Afghanistan, the long lines in South Africa. We've seen, however, that autocrats subvert the rights of their citizens. In Iran in 2009, the mullahs were caught by surprise and had to resort first to fraud and then to force. In Russia, Vladimir Putin actually accused me of personally engineering the massive protests that followed the controversial parliamentary elections of 2011. Of course, Americans have had to fight to safeguard and extend their right to vote as well. When I was growing up in Illinois, the youth minister from our church took a few of us into Chicago on a cold January night to hear Dr. Martin Luther King speak. And afterwards, I stood in a long line to shake his hand and thank him for his work. I was a senior in high school in March of 1965, sitting in front of our black and white television set when President Johnson made his historic call for passage of the Voting Rights Act. His first words were, "I speak tonight for the dignity of man and the destiny of democracy." In 1972, the Democratic National Committee sent me to register eligible voters in the Rio Grande Valley in Texas. Now, some of the people were understandably wary of a blonde girl from Chicago who didn't speak a word of Spanish, or Texan for that matter, but The law belonged to them as much as to me, and they wanted to vote. Now, we have made real progress since those days, but we still have deep flaws in our electoral system. Between a quarter and a third of all eligible Americans remain unregistered and therefore unable to participate. Compare that to Canada, our neighbor, where most citizens are registered automatically to vote when they turn 18. I held a forum in Cleveland after the 2004 election with my friend, the late Congresswoman Stephanie Tubbs Jones. There were reports of African Americans waiting in line to vote for 10 hours, while whites in affluent precincts next door waited just 10 minutes. African Americans received flyers telling them the wrong time and day to vote. Students from Kenyon College told us they had to wait half a day to cast their votes. They were registered, they were eager to vote, but the machines were allocated in a way that ensured young people would face long lines. In the years since, we've seen a sweeping effort across our country to obstruct new obstacles to voting, often under cover of addressing a phantom epidemic of election fraud. Like when the Attorney General of South Carolina justified a harsh new voter ID law by declaring that, and I quote, "We know for a fact that the identities of many dead people had been used for fraudulent voting," a claim soundly rejected by a subsequent state investigation. In 2013 so far, more than 80 bills restricting voting rights have been introduced in 31 states. Now, not every obstacle is related to race, but anyone who says that racial discrimination is no longer a problem in American elections must not be paying attention. And despite the best efforts of many well-intentioned election officials, discrepancies in resources across precincts and polling stations still disproportionately impact African Americans, Latino, and young voters. That's why the Voting Rights Act, especially its requirement that jurisdictions with a history of discrimination pre-clear changes in their election procedures, has played such an important role for nearly half a century. In the past 15 years, under both Democratic and Republican presidents, the Department of Justice has used the law to block nearly 90 discriminatory changes to state and local election rules, and many more were withdrawn under scrutiny. Just since Congress reauthorized the Voting Rights Act in 2006, more than 30 proposed changes have been stopped. As you know, the Supreme Court recently struck at the heart of the Voting Rights Act and stripped out the pre-clearance formula that made it so effective. Some take the historic success of the Voting Rights Act as a sign that discrimination is a thing of the past and we no longer need its protections. But as Justice Ginsburg said, that is like throwing away your umbrella in a rainstorm because you are not getting wet. You'll soon be soaked. And sure enough, in the weeks since the ruling, we've seen an unseemly rush by previously covered jurisdictions to enact or enforce laws that will make it harder for millions of our fellow Americans to vote. Texas hurried to move forward with a voter ID law that a federal court had already invalidated. And by the way, it would allow a concealed weapon permit as a valid form of identification, but not a student ID from a state university. That certainly seems to violate the spirit of the Supreme Court's 1979 Sim ruling, which protects the voting rights of college students. Florida is restarting a purge of the voter rolls that, even with better lists, is likely to disproportionately affect minority voters and bring back memories of the 2000 election and the scores of wrongly disenfranchised voters. Last year, state officials drew up a list of 182,000 voters they suspected to be non-citizens. Further investigation determined that only a fraction of 1% were actually ineligible. Legislators in North Carolina have pushed through a bill that reads like the greatest hits of voter suppression. Restricted early voting, no more same-day registration, or extending voting hours to accommodate long lines, stricter photo ID requirements that disqualify those issued by colleges or public assistance agencies, and it goes on and on. These are all changes that would have required federal approval under the Voting Rights Act, but now can go forward without scrutiny. By invalidating preclearance, the Supreme Court has shifted the burden back onto citizens facing discrimination and those lawyers willing to stand with them. While these high-profile state laws get most of the attention, we should remember that a lot of the damage will occur below the radar at the local level. That's where the Voting Rights Act was so important, in the small places close to home. So many potentially discriminatory changes do not require legislation or public debate. Shifting poll locations and election dates, scrapping language assistance for non-English speakers. Without pre-clearance, no one outside the local community is likely to ever hear about them, let alone have a chance to challenge them. Quick examples among scores of others. In 2001, a small town in Mississippi tried to cancel local elections after black citizens became a majority of registered voters. The Department of Justice intervened, an election was eventually held, and the first African-American mayor was elected. In Charleston County, South Carolina, after African-American candidates won a majority on the school board for the first time ever in 2003, county leaders attempted to resurrect voting procedures nearly identical to those that had already been found to violate the Voting Rights Act. Once again, the Department of Justice was able to stop the change. And in 2007, the Texas legislature quietly amended the eligibility requirements for supervisors of water districts so that only landowners could serve. The Department of Justice blocked enforcement of the new rules, noting that they would disqualify a number of incumbent Hispanic supervisors and that there was a significant disparity in land ownership rates between whites and minorities. Unless the hole opened up by the Supreme Court's ruling is fixed, future cases like these will end very differently. Citizens will be disenfranchised, victimized by the law instead of served by it, and that progress, that historical progress toward a more perfect union, will go backwards instead of forward. So what can we do, and why am I talking to you, the members of the House of Delegates, about what can happen and what you can do? I think we need an approach that moves on multiple fronts at once. Stepped-up enforcement by the Department of Justice, new legislation from Congress, and grassroots action by citizens and lawyers across our country. First, as Attorney General Holder is already doing in Texas, the Department can redouble efforts to enforce other sections of the Voting Rights Act to undo discriminatory election changes. The Department can work to build a new list of jurisdictions for pre-clearance based on recent abuses. That would be easier and more effective if Congress shifts the standard for bringing a jurisdiction under federal oversight from one of discriminatory intent to one of discriminatory effect. It might also make sense to allow citizens and civil rights organizations and lawyers to trigger federal scrutiny of problematic election practices by filing a simple one-page complaint rather than a full lawsuit. Of course, that would also require an act of Congress. So second, Congress should move quickly to pass legislation to replace those portions of the act that the court struck down. I was in the Senate in 2006 when we unanimously reauthorized the law after what Justice Ginsburg described as an exhaustive, evidence-gathering and deliberative process. More than 20 hearings in the House and Senate Judiciary Committees, testimony from expert witnesses, investigative reports documenting continued discrimination, more than 15,000 pages of legislative record. The Republican chairman of the House Judiciary Committee called it one of the most extensive considerations of any piece of legislation in his nearly 30 years of service. And after an overwhelming bipartisan vote, President Bush pledged to vigorously enforce its provisions and defend them in court, which his administration did. Our process in the Congress in 2006 was an example of how the system is supposed to work. We were guided by evidence and facts, not ideology. We put principles ahead of politics. That's what Congress needs to do again. It should reinforce the fundamental principles of the Voting Rights Act and ensure that citizens have the information and access they need to fully participate in our democracy, and at the very least, future changes to election procedures should be subject to mandatory advanced public disclosure that includes enough information so that citizens have a chance to analyze and understand what's happening and seek a remedy if there is discrimination. And beyond the Voting Rights Act, Congress should also consider additional measures to improve elections in the country, including reforms that would make it easier for people to become registered and stay registered. The Bipartisan Commission to Improve Voting that President Obama announced in his State of the Union address is a good start. It is chaired by his campaign lawyer and the Romney campaign's lawyer, and I hope its findings receive a serious hearing when they are announced. In the Senate, I championed a bill called the Count Every Vote Act, would require making Election Day a federal holiday, require states to work to reduce waiting times at polling places, provide early voting periods, put in place fair and uniform standards for voter registration and identification, including same-day registration across the country, as well as make it a federal crime to deceive voters, like by sending flyers to minority neighborhoods with false information. It was important to provide a paper record and improved security measures for electronic voting machines as well. Now, there are many problems in life that we can't fix, at least not quickly, but preserving fairness and equality in our voting system is one that we can and we should. As Secretary of State, I saw other countries take steps to increase voter participation and strengthen their democratic processes. There is no reason we cannot do the same here in America. I'm well aware that persuading a gridlocked Congress to address these problems will not be easy, but that doesn't mean we should give up and walk away. We should redouble our efforts, and this is where all of you come in. Enforcing the Voting Rights Act has always depended on activists and advocates working at the grassroots level. Now more than ever, that is what we need. I want to praise the ABA for your strong stand. Your amicus brief in Shelby urged the Supreme Court to uphold the Voting Rights Act, because its work was not done and its protections against discrimination were still needed. Since 2004, the ABA has worked with the Nonpartisan Election Protection Coalition to provide on-the-ground legal assistance to voters, especially in minority areas. Volunteers have fielded complaints on telephone hotlines, interceded with state and local officials to prevent abuses, and spent countless hours in polling places and courthouses. And I understand that the ABA will mark Law Day 2014 next May 1st with the theme, Why Every Vote Matters. When I chaired the ABA Commission on Women in the Profession and traveled all over the country talking to lawyers and judges and bar associations and law firms, really anyone who would listen to our findings, I saw firsthand the power and reach of the people in this room and who you represent. You know the law. You speak the language, you can harness its authority. That gives you a unique ability to drive progress, right wrongs, and help our nation live up to our finest ideals. No country has a richer tradition of lawyer citizens than the United States, from John Marshall to Thurgood Marshall, from Margaret Brent to Laurel Bellows. So I ask each of you to take up this cause in your practices and communities. Educate your neighbors, your local leaders about voting rights. Scrutinize changes to election procedures. Write an op-ed. Call a congressman. Tell them you believe in the right to vote, not just for yourselves, but for your fellow citizens. And tell them that our government cannot fully represent the people unless it has been fairly elected by them. So as you go home, to your local bar associations, to your courthouses, to your law offices, please ask yourself what more you can do on your own, with your local bar association, with the ABA, to be that advocate for justice. How can we bring the law into people's lives and help it serve and empower them? One of my early mentors as a lawyer was John Doerr, who argued pivotal voting rights cases for the Kennedy Justice Department. In 1963, in Jackson, Mississippi, John stepped between angry protesters and armed police to prevent a potential massacre after the murder of Medgar Evans. That was the kind of lawyer and leader he was. Years later, he gave me a photo with an inscription from Tennyson's Ulysses: to strive, to seek, to find, and not to yield. Our nation's greatness is not a birthright. It must be earned by every generation. I am confident that we can earn it for this time. We're at our best when we live our values, including our devotion to democracy and protection under the rule of law, when we widen that circle of opportunity and extend dignity to all of our citizens. I believe strongly that that is what is called for today. And there is no group that I have more confidence in being able to rise and meet that challenge than the lawyers of America, and particularly the American Bar Association. Thank you all very much.